Welcome to yet another edition on Quest Television and Quest 93.1 FM. It's Law, Society and I. And as you do know on Law, Society and I, what we do is educate you and inform you on how to be on the right side of the law in the society. I am Chinyere Abiamawe. What we'll do right now is go on a short break, and when we return, I'll be introducing the guest as well as the topic for today. Please stay with us. There are certain amounts of care or precaution a person owes his or her neighbor, whether we are related by blood or close friends or even a stranger. Just as it is in most religion that we are our brother's keeper, so it is in law. There are consequences for failure of being your brother's keeper, just as there are consequences in the religious aspect of it also. Legally, you are expected as good citizens to be your brother's keeper, and failure to exercise such attracts fines, jail term, or other grievous punishment. On today's edition of Law, Society and I, we'll be talking about negligence, but we'll be extending it a little bit further to medical negligence, negligence between an employer and an employee. Yes, a few weeks ago, I'm sure most of us must have heard the story of a student in one of the universities who died as a result of, so they say, negligent act of the authorities. Also, we've heard stories of how people have suffered unjustly as a result of medical negligence. Recently, a very good friend of mine was a victim of that too. Most times, most people decide to say, let God judge. But the truth is, will God come down to judge on your behalf? There are certain steps you need to take legally for you to get compensation. Obviously, the life that has been lost can't be recovered. True. Also, the body part that has been maimed can't also be recovered. True. Well, as you do know, I am not alone in the studio. I have a special guest here with me, a friend and a colleague. We have no other person than Barrister Charles Ogenedoro. Thank you so much for joining us on today's LSI.
Thank you. Welcome.
Thank you so much. Before we go into the crux of the issue, medical negligence and negligence between employee-employer, let's start with the foundation. What is negligence in law or general parlance?
Okay. When we talk about negligence, we're looking at tort. And in tort, negligence is failure, or let me say refusal to exercise reasonable care that is expected of a reasonable man, in which such omission or commission causes harm to another person. Now what I'm trying to explain is that act which you were supposed to do that you do not do, or that act which you were not supposed to do that you did, and later resulted into harm of another person, such act is negligence.
Okay. In the course of your definition of negligence, you made mention of a reasonable man. Can you throw a little bit more light on that? Who is a reasonable man?
Now, when we talk of a reasonable man, I'll use the term a rational man, a man in his right sense. Now, there is a level expected of every man in the society. You understand? Now, there's a level of expectancy from every man. So we talk of a reasonable man, we're talking about the rational man, the well-thinking man that is normal, that knows what is good from what is bad, that knows what to do at a particular point in time, that knows how to respond to a particular situation. So that's how I see a reasonable man.
Okay, in law, is there any yardstick for you to say this person has acted in a reasonable way, this person has not acted? Is there any yardstick to measure?
Yes. Now, the issue of measuring whether or not a person has acted in a reasonable way is a question of fact.
Okay.
Yes, it's a question of fact, in the sense that the way I may act in a situation can be termed to be reasonable, and I will act in that same way in another situation, and it will not be termed to be reasonable.
Okay.
So first of all, when you look at the reasonability, it depends on the circumstance and the amount of injury that your actions may result to. For example, a man who is carrying an AK-47,
okay,
a higher level of reasonability is expected of that man compared to a man who is carrying, let me say, a sniper.
Okay.
You understand?
Yes.
So a man who is in possession of an AK-47, there's a high level of reasonability you are expected to do or to exhibit with that AK-47, knowing fully well that once you pull a trigger, a life is gone. Then compared to this other man that is dealing with, let's say, fire or something that could just cause a meager harm. So the issue of reasonability is a question of fact, and it depends on the circumstances
of each case. Okay. Now, do we have laws in Nigeria? We are in Nigeria, so I really like us to dwell here. Do we have laws in Nigeria and in Delta states that regulates this discussion to that negligence?
Yes. There are laws that regulate negligence. For example, the criminal code.
Okay.
Yes, the criminal code provides for the criminal aspect as per negligence.
Okay.
Section 343 thereabout provides that anyone who omits or does an act that causes harm to his neighbor, such persons shall be liable for imprisonment no less than 6 months. So that's for the criminal aspect. Why there are other civil laws, you understand? Go to court, file your civil claims for negligence. You understand? There are case laws, you understand, that are applicable as to negligence.
So what court has jurisdiction to entertain this suit?
Mostly it's the High Court. It's the High Court. High Court entertains negligence, but you can also go to the magistrate court. It depends on what you are claiming. No fully way that the claim, the jurisdiction of court is determined by the claim. So you can go to the High Court, you can go to the magistrate court. It depends on the circumstance and what you are claiming.
All right. You were talking about duty of care.
Yes.
In the course of your definition. Is it possible for a person to owe a duty of care to another, a stranger?
Well, talking about duty of care, ordinarily you owe everyone duty of care.
Okay.
You owe everyone duty to be careful with what you do, to make sure that your act does not affect another person. But however, you don't necessarily need to impose a duty of care on yourself.
Oh.
Let's say, for example, I'm walking by a street and I saw a little baby falling on the way or falling inside the way. Okay. Now, I'm going to say this per law. Morally is right. But you know that I don't owe that child the duty of care to bring him or her from that way.
Okay.
Also, I'm driving along the road and I see an accident victim. He or she is crying, "Barrister, help me, help me, help me." I don't owe him a duty of care to take him to the station. I can just to the hospital rather. I can just stand by with sorry, this person is wicked. But I don't owe him or her the duty of care to take her to the hospital. I can just say sympathize and drive away. You understand? So it depends on the circumstance. If the act or the injury is not caused by your act, then you don't owe that person a duty of care. But if the injury is caused by your act, then you owe the duty of care
to every person. Now, what are the defenses available? You've been talking about injuries, owing a duty of care. Do we have any defense available in any negligence act?
Yes. You know, there are different defenses that are valuable as per claim for negligence. Now, the first is contributory negligence.
Okay.
Now, what I mean here is that you contributed to the act that caused you injury. Fine, I started it, or fine, I omitted to do something, or I did something, but then you had the privilege of averting sin. Okay, for example, I employ you in my company, and I provided the helmet, the safe walking
Kits.
tools to you, and you fail to use them, and then at the end of the day something happened, you contributed to it. So you cannot come in turn and say that
So as a
I should be
result of
liable for
yes,
for the negligence. You understand? He who comes to equity
must
must
come with
come
clean
with clean
hands.
hands.
That's
You
true.
understand? So that is as to contributory negligence.
Okay.
Now there is another defense of consent. You consented to the act. Yes, and let's say for example, how will I? Okay, let's say for example, I want to bore or I want to drill a borehole now in my compound, and then we agreed. I met you. This is it. I want to do something. And you said, okay, go on. Let's even drill it so that it will serve everybody. And along the line, during the drilling process, maybe there was an error and the water escalated into your house and damaged things. You cannot come and say that I was negligent. We agreed that let's put this thing. We both consented. And I think that is why most doctors will say sign.
But don't you think there are certain precautions that you should consider before drilling the borehole or agreeing to carrying out a particular act?
Yes. Yeah, that is why I said every issue as to negligence is a question of fact. The court will look at the other aspect of whether you are supposed to take precautions and you did not take it. You understand? And I think that will not go to an issue between the workers, not the owner of the borehole now. You understand? So that will not go to the issue between the workers and the person that is being injured. But on the other hand, as to the person that owns the compound, for instance, we consented, we agreed to it. The same thing happens to in the hospital where they bring the forms for you to fill and then you sign. You are consenting for them to go on whatever they are doing. And then there's another defense of new development.
Okay.
Yes, while I was doing this, I did not know that this would come up. While I was doing this surgery, I did not know that this other issue would come up. Understand? And then this new development can also be likened to emergency. It was an emergency step that needed to be taken. It can come as a defense that the situation just came up unprepared. Nobody knew it was going to happen, and a step was needed to be taken, and we had to take this emergency step. So these are some of the defenses that are valuable for negligence.
It's already an established fact that negligence can occur when there is a failure to carry out precautions or care
Yes.
that has to do with your neighbor or another person.
Yes.
So my question is, who is my neighbor? Is my neighbor the person living in my next apartment? Is my neighbor the person sitting close to me in a bus? Who is my neighbor? Is there a legal definition for neighbor?
Yes, the common man, the layman, my neighbor is the person living next to me.
Yes.
That's by the layman, but in law, that is not actually the definition of my neighbor as it relates to the act of negligence. Now, when you talk of my neighbor, Lord Atkins clearly defines my neighbor as that person or the people whose my act or omission will affect. So that person that if I fail to do something or I do something and another issue comes up, that person that will be affected by my act or my omission is my neighbor. If I'm driving along the road, the other car users, even the ones trekking, they are my neighbors, because if I lose control of my steering and anything happen, they are the ones that will be affected. So that's the definition of neighbor, my neighbor simpliciter. Anybody that will be affected by my act or my omission is my neighbor.
I would like us to remain there. In the course of the discussion, you made mention of you not owing a duty of care to someone that is injured, not as a result of your omission.
Yes.
Now, you are driving by and there's an accident scene by the roadside. You have a car. You have fuel in your car.
Yes.
And instead of you to be sympathizing with the victims of the accident and they are bleeding profusely and you're like, oh, sorry, and you just drive past, don't you think you have neglected your neighbor?
No, I have not neglected my neighbor. In law,
Okay.
But morally, everyone will say that he's wicked. Please, I'm not saying this so that you see an accident victim on the road that you just zoom off. But that is the law. The law is that I see my neighbor there, maybe involved in an accident, which I had no idea of what happened. I don't owe my neighbor the duty to rush him to the hospital. I cannot stand up and do, But let me tell you something. The moment I take step in rescuing that person, from that moment, I owe him a duty. That is the difference. The moment I take step in rescuing that person, from that moment, I owe him a duty. I owe him a duty to be careful with him. I owe him a duty to, if possible, give him the possible first aid and treatment. You know that there way you carry patients. I owe him the duty to be that careful. But if I don't take any step and I'm just standing there and I'm sympathizing and I'm I don't. There is nothing. I have not committed anything in law. But the moment you take a step in taking that person, from that moment you owe him a duty of care.
Okay, speaking of standard of care, do we have exceptions to standard of care to the reasonable man?
You know, it's still a question of fact.
Facts.
Like I said before. Now, how would the court determine if the standard of care you exercise was really according to the one that a reasonable man will exercise in your situation? Now, let me go back to the first scenario I painted of you having an AK-47.
Yes.
And then you are with an AK-47, you know fully well that is fully loaded. With cartridge, and you are facing it on a neighbor like you feel you are playing with it. Or okay, fully loaded, you are swinging it up and down. I don't think that would be a proper, that would be said to, I don't think you will be said to have exercised the reasonable care. Because what you are holding is so destructive that the standard of care that is expected of you is very high. You understand?
Yes.
So when it comes to this standard of care, it depends on this. Okay, for instance, again, you have a child in the house, and maybe you have reasons to kill these mosquitoes and all of that, and after pouring the sniper, you left it down. You left it where this child can go to. You understand? And then eventually the child crawls to that place. The child that does not know whether this is a chemical or water,
or not,
and maybe he or she is thirsty, and then he drinks the sniper and died. Nobody will say you've exercised a standard level of care. You understand? So like I said, it's a question of fact. It depends on what you that is carrying 80 passengers. There's a level of care that is expected of you as against you that is carrying just one person. You understand?
Yes.
So it is a question of fact when it comes to standard of care.
All right. So what are the claims to a victim that has suffered from any of the negligence? Because right now, we have not really gone to the medical aspect or the employee, but generally, what claims does a victim have?
The first thing first is damages.
Okay.
Yes, you can excuse me, you can go to court and tell the court that this act of this person has made me suffer a lot, and I'm asking for $5 million, I'm asking for 5 million naira, so as the case may be. And then the court will look at the situation and say, okay, yes, this act is really so dangerous and this person has suffered a lot, and by so we're awarding the cost of 5 million naira. So that's one of the claims. Now, you can also come to court and say that I want restitution.
Okay.
Yes, the act of this person damaged my crops. The court should order that the person should replace my crops. You understand? Plant them back. Take care of them till they get to the level they were when your acts.
Before
you understand?
yeah.
So the court can also order restitution. Now, also, there's compensation. Compensation also falls with damage.
Damages. Okay.
Yes.
Okay.
Now, another remedy that will be available is you can tell the court that this person is not fit. This person is not fit to be in this company. Look at this act. The court should give an order urging the company to relieve this person of his duty. So that's another remedy you can get. To get him relieved of his duty. Or even if he's a medical practitioner, you can get an order to get his license seized or released for a period of time. So these are the available remedies.
Now, you've been making mention of courts, going to high courts, magistrate courts. What do I need to prove? What do we need to prove for us to be able to succeed in any case that has to do with negligence?
Okay, yes. For you to succeed in a case that has to do with negligence, the first thing you need to prove is that this person or these people owe you a duty of care.
Okay.
You have to show that they owe you a duty of care. Now, I'm going to give an example. Let me just list the element. First, you show that they owe you a duty of care. And secondly, you have to prove that that duty that they owe you has been breached.
Okay.
Yes, it has been breached. And thirdly, you have to prove to the court that you suffered damage. You have to prove in court that you suffered damage. And finally, the court will now look at the remoteness of the damage. Now, let me give an example. Mr. A went to a club. He's drunk, and then entered his car. He's driving home drunk, and then along the way he lost control, and an accident happened, and he hit Mr. B. And then Mr. B comes to court. First of all, what is the duty of care there? Mr. A owes Mr. B the duty not to drive while in the drunken state.
Okay.
You understand? So that is the duty that Mr. A owes Mr. B. Do not drive while you are drunk. You owe me that duty. You owe me the duty to maintain safety cautions while driving. And now you are driving and you are drunk. And then you have to now prove to court that this duty has been breached. How do you prove to court? You tell the court that now this person lost control of his steering, and that is why he hits me. And he has breached that duty not to hit me, as a matter of fact. Yes, he owes me a duty not to hit my car. Drive your lane, I drive my lane. You understand?
Yes.
And then having breached that, having hit my car, you have breached that duty. And then the next thing is, you tell the court, look at my bumper, he's destroyed. That's the damage we're not talking about.
Yes.
Look at my bumper, look at my side mirror, look at my left door. They are worth so amount. They've destroyed them. You can even tell the court I was traumatized. Yes.
But traumatization cannot be proved.
It cannot be proved, but the court will still well into it. The court will look at the extent of the damage. I mean, someone that is earning, let's say, 10,000 and struggled to buy a car, and you destroy that car, the person is telling the court is traumatized. You think the court will not consider it? You will consider it. You will look at what are the things this man had to go through in getting this thing. This man could be right in, you know, there's some things that will happen, and blood pressure will come. Maybe the man sold all his property to get that car, and then you are destroying that. You say the man cannot tell court that he's traumatized. He is actually. So the court will look at that also. And then another thing the court will look at is, what did you do when the accident happened? Is there any possibility, or was there any way you would have averted it on your own part? Or is there any way you would have limited the level of the damage that's caused to your car? So the court will look at this. So once you are able to prove these 4 factors, trust me, you get whatever you want in court.
Trust me, I think I like that part. But please, what we'll do right now will not be negligent enough not to go on a break. We'll go on a short break, and don't forget, it's Law, Society and I. And the topic for today is negligence. Yes, indeed, it has been an interesting one, and educating one, and also an informative one. Yes, so right now we'll go on a break, and when we return, we'll continue with the discussion. Indeed, our guest is doing justice to today's edition of Law, Society and I. Seriously, I'm enjoying today's topic. Thank you very much. We'll go on a break, and on return, I'll be opening up the lines for you to make your comments, ask your questions, and your contributions. Please don't go nowhere. Welcome back. It's Law, Society and I. And our topic for today is negligence under the Nigerian legal system. Yes, so far so good. I would like to do a little bit of recap on what we've discussed so far, just in case you're joining us. Negligence, yes, the failure to take necessary acts or precaution or care concerning your neighbor or a person that is close to you. Who is your neighbor? Your neighbor is not just the person living next door. Your neighbor is the passerby on the street. Your neighbor is the person sitting close to you in a vehicle. Your neighbor can be anybody that is a human being. Yes, you don't owe a duty of care to everybody, yeah, that's true, but you owe a duty of care to your neighbor. Yes. Also, defenses available to negligence. We have a contributory defense, new development defense. We have some other defenses too. Yes. Is it possible for a person not to owe a duty of care to another? Yes, it is possible for you not to owe a duty of care to another. But the moment you get involved, like the accident scenario legal practitioner here just mentioned, the moment you get involved, there are duty of care that you need to take, precautions you need to take. Yes. What are the claims of negligence? Peradventure, you are a victim, you can get damages compensation, you can get restitution, and you can also ask the courts, pray the court for an order to relieve the person of his or her duty depending on the circumstances of the case. Yes, negligence is an issue of fact depending on the circumstances of each case. Now, we would like to proceed a little bit further to negligence between an employer and an employee. Now, before we go down into the crux of the issue, I would like us to give a little bit of a definition. When you say negligence between employee, employer, what does it really mean in a nutshell, please?
What it means here is when an employer employs a person,
yes,
the employee, or the employers rather, they owe the employee a duty of care. The duty of care to make sure that the person they are employing is not injured while working.
Okay.
And once they breach that duty, the employee has the right to take an action against them for negligence.
Most times, what is common these days is most organizations, most private industries don't have these contracts, employer-employee contracts where you sign in. Now, for me to be able to succeed in a case of negligence that happened in my place of work, do I need to prove that? Do I need any document to show that I used to work here or I work here and this happened as a result of me working in that place? Should there be a contract for me to succeed?
Definitely. Once you are employed by a company, a corporate organization, there will definitely be contract of employment. There will definitely be terms of employment. I think what we would be asking here is that does that mean that, or how would I put it now? If what we'll be asking is, does the employee need to have a clause to provide the necessary safety tools? That should be what we'll be looking at now. And now, because some employees will come, they will tell you that it's not in the contract that was given to him. You employ a welder, for example, and you do not give him helmets, you do not give him jackets, and then in an action for negligence against you, you will not say that their defense will not be in their employment. It was not stated that we should give them jackets or helmets. No, there's an ILO convention, which is the international standard when it comes to employer and employee. And there are implied terms that are in favor of the employee. First of all, the employer is obligated to provide the appropriate working kits, which includes the tools, the helmets, the jackets, the footwear, as the case may be.
Yeah, that's safety boots.
Safety boots, okay. Yes. Now, secondly, the employers, they are expected to provide a safe working environment. A safe working environment. It is a duty imposed on them via the ILO convention. It doesn't have to be in any contract. Thirdly, they have to provide a safe working policy. I mean, how do you engage someone that's working with okay, how do you employ a welder, for example, that does hard work, and you tell him to work for full 24 hours, and after 48 hours he collapses, and you say you will not be responsible? That is not a safe working policy. So you are obligated to provide a safe working policy for this person. You understand? And then, so the point I'm trying to make is that they don't have to be inserted in any contract formally. their implied terms via the ILO conventions. They are international standards that every employer must abide to. And once these are breached, it is enforced. Also, you know that the National Industrial Court that deals with the employer and the employee, they've been enjoined to do what? To make reference or to rely on international standards. Okay. So as it stands now, ILO conventions are enforceable in our National Industrial Court. As it stands now. So that is the provision. You don't need to put them in the contract. And definitely, if you are employed, there must be there will be contract of employment, which you show to court that yes, I'm contracted with this company, but they failed to provide the necessary tools, and hence here we are.
I think we are going a little bit too high. Now, speaking of terms of contract, the roadside mechanic, the roadside welder. Now, you see little children who are learning how to repair tricycles, repair bikes and vehicles. Are you also saying that the man that is by the roadside, I don't know if you're getting my point. Yes. Now, we are saying what you're saying is applicable to big construction companies, big firms, organizations and corporate firms. Yeah. Now, I'm talking about the roadside employers. Do they need all this? Because in courts, most of their businesses, so to say, are not registered. Yeah. So do they need all these things, all these terms of contract to prove?
Okay, you know, this when you talk of the roadside mechanic,
yes,
their case is quite peculiar and unique.
Okay.
But however, what I know is that ignorance of the law
is not an excuse.
Yes. That's what I know. So even the roadside mechanic, you are obligated to take care of the person that is learning under you. That is why when you see most of these roadside mechanic, what they do is they will mandate you to buy those things because they know they can't provide them for you. So they will tell your parents or whoever is signing the work for you, will tell you, provide these things for them, buy these things for them. And like I said, when it comes to negligence, it's a question of fact. The court will also consider, does this roadside mechanic has the money to buy these things for the apprentice? Or, okay, now we're talking about an apprentice now.
Yes.
He's learning. So I don't think there is a contract, an employment contract between them because he's not an employee, he's as an apprentice. You understand? So the court will look at this fact. Does this roadside mechanic even have this money to buy these things? And then this roadside mechanic can come to court and tell the court that, yes, I told the parents, I told them, buy these safety kits for the children. And that is where we talk of contributory negligence. The man has told you, buy these things for your children or for whoever is learning the work. You fail to. And now this person has sustained injury. You want to take him to court for negligence. The court will look at all these facts also in determining whether the roadside mechanic will be liable.
Well, in case you're just joining us, it's Law Society and the topic for today is negligence under the Nigerian legal system. In the course of my research, I came across joint liability under employee-employer negligence. Can you throw a little bit more light on that for us to know what it actually entails?
When you talk of joint liability, now there's the issue of vicarious liability that flows with joint liability. You understand? The concept of joint liability is usually is often not invoked that much. Now, who and who will be liable together? Okay, now let me give an example. An employer employs Mr. A and Mr. B to work in a firm or in a place. And then Mr. B makes the mistake or negligently did an act that caused injury to Mr. A.
Okay.
Now, is that issue who will be liable for negligence? Is it Mr. B that did the negligent act or the company that employed an incompetent Mr. B? That is where the issue of joint liability comes in.
Okay.
And I tell you for a fact that the company and Mr. B will be jointly held liable for negligence. Okay. Now, because the company owes Mr. A the duty also to employ competent workers that will work with Mr. A. They owe him that duty. And if the company fails to employ a competent worker to work with Mr. B, and they employed an incompetent Mr. B, who now did an act that caused damage to Mr. A, Mr. A can hold them jointly for negligence. The company failed to employ a competent person, and the incompetent person did an act that caused me injury. So that is where the issue of joint liability comes in, which also goes pari passu with the vicarious liability. Having employed an incompetent person, you are vicariously liable for any act that such employee that is incompetent, which your company has employed, as any act that he did, you are vicariously liable for such acts.
All right, thank you so much, Barrister Charles Ogene Doro. Well, what we'll do right now at this point is open up the lines for you to make your contributions, ask your questions, and also comment on today's Law Society and I. And the topic is negligence. The lines to call are 080-22-931-931. I go again, 080-22-931-931 or 081-888-88931. or 081-888-88931. Well, if you're watching us on TV, the numbers are right there on the screen. And remember to turn down the volume of your radio set, or better still, walk away from your TV set so we can hear you very audibly. Now, I would like us to, before the call starts coming in, I'd like us to go down to medical negligence.
Hello?
Hello, good afternoon. Welcome to the show. Your name and location, please.
My name is Tega Apostle. I'm calling from Ozi, Delta State.
Okay, Tega, you're welcome. Please have your say.
Okay. I have a question.
Okay.
Concerning the case scenario.
Sorry?
The case then.
What if I, as a driver, who just finished amending my car, and I did not know that a mechanic who amended my car did some errors, and I'm driving that car, and in the process of driving, there's a brake failure, and I knock down someone. I'm not aware of this. What would be the situation at that point?
Over to you, Barrister.
Yeah, that is where the joint liability comes in. Yes, that's where the joint liability comes in. Now, you owe other road users the duty to meet a competent mechanic to repair your car.
How do we know competent
That
mechanics?
is exactly the question of fact. Joint liability comes in again. You owe the other road users a duty to meet a competent mechanic, if possible. It's just that because of the situation of the country, in most of the advanced countries, you don't see these road mechanics. There are more of companies. You go to the companies, they attend to your car. You understand? So in that situation, I'm sorry, sir, you and the mechanic will be jointly liable for negligence. It's as simple as that, because you did not meet a competent mechanic. It is the only thing the court would do in that situation is the court might award little cost against you, and then more court against the mechanic who did the act. But honestly, you owe other road users a duty to meet a competent mechanic. And if such failed and he does something that cause accident, you will be liable also for not meeting a competent mechanic, and that incompetent mechanic
will also be liable.
liable.
Okay, before the call came in, I was trying to ask about medical negligence. We've heard stories, we've seen people that have been maimed, their legs amputated, and so many things like that have been happening. I don't know, is there anybody that you can report to? What are the steps you can take when we know those things can't obviously be recovered, an amputated leg can be fixed back and all that, but
in all honesty, our medical practitioners are trying.
Yes,
it is not easy.
It's not easy.
Yes, it is not easy. And I honestly believe that no medical practitioner would deliberately want to do any act that will cause damage to any person. But if such happen, definitely there are bodies that you can report to.
Okay.
And then but then even before going to this body, if it's something that can be repaired, I've heard of a situation where a doctor did an operation and he forgot scissors in the is this stomach or the stomach of the
yes,
person?
towels, cotton wools and all that. I've heard stories like that
and
too.
the person went back. It was removed and the person was compensated. I think that is a reasonable man's compensation.
Okay.
You understand? And which I feel is fair, because I honestly feel that that doctor did not deliberately leave that.
Obviously, it wouldn't be a deliberate act.
It's not deliberately leave there. So, but there are bodies you could report to, and then you can meet the medical practitioners and disciplinary committee. I will just stick to that particular one.
Okay.
I think they are the best persons. But I would not advise this medical practitioner be put under immense pressure of bringing frivolous cases of negligence against them. Because if we are doing all of that way, it means I will tell you that just do the little you can. Maybe a medical doctor would want to take a risk to save your life, but because of the fear of if that risk is going to take now does not come out where you would not want to take such risk, and you just end up losing your life. So I would advise that we are being careful when it comes to the medical practitioners as per the issue of negligence, so that we don't deter them from doing their work for food.
I also feel we should kind of limit the pressure we give to them while they are working.
Yes.
Sometimes they are humans too,
Exactly.
So they also have ability to respond to pressure positively or negatively.
Yeah.
That's it. Okay. Now my question is, hello, good afternoon. Hello, good afternoon. Your name and location, please. Okay. I think we could not establish that call. Now, I want to know, is negligence a crime in Nigeria?
Yes, I already said that. A crime. What is a crime? A crime is an act that is punished by law.
Criminal, civil.
Criminal, crime, criminal law. Any act that is punished by a law is a crime. The criminal code, any act that is prescribed in the criminal code or other criminal enactments wherein there are punishments is a crime. And I already mentioned that in the criminal code, there is a punishment of 6 months, not less than 6 months imprisonment for any act of negligence. So it is a crime. So
there is no criminal liability and civil liability when it comes to negligence?
Yes, criminal liability is what makes it a crime, is the criminal aspect. While the civil liability, it is the actions you take in court, either the high court or the magistrate court, wherein when it comes to civil, you are not sentenced to jail or anything because it is not a criminal matter, it's a civil matter. So when we talk of the civil liability, that's when we talk of remedies such as damages, restitution, or retrieval of licenses. Those are the civil remedies. While the criminal remedies, the person might be sent to jail or other community services.
Now, nobody wants to be liable when it comes to negligence. Is there any ways we can protect ourselves from being liable, from acting negligently that will cause harm or harm generally to my neighbor?
Take caution. Take caution. Be careful. Be careful. And then, as an expert, the duty of care is even more on experts. As an expert, as a medical doctor, for instance, that you know that a life is involved, you are expected to take high level of caution when you are doing your operations. Even it goes as far as to the diagnosis you give. You understand? Someone that is suffering from cancer illness, you are prescribing some drugs that would exacerbate the cancer itself. That is negligence. So you have to be careful. Even lawyers. So matters I will know that thank God for the Supreme Court that are awarding costs against lawyers now. There's even a high level of care that we're expected to take when it comes to dealing with our clients, the kind of advice you give to clients. You have a situation where you hear lawyers tell their client, go and fight them, go to the land, go and and these things, they happen. So even lawyers, doctors, those professionals, there's a high level of care. So we have to just be careful, and in all we do, we should put the reasonable man's test.
Yes.
What would the reasonable man in my position do in this circumstance? And what would do all of this would avert the liability of negligence.
And one will take necessary care, one will take necessary precautions, and will avert so many evils. Now, in all of this, most persons will not want to go to court. And is there any other means aside going to courts? Can we sit on a round table and talk? Is there room for settlement?
Yes, there are rooms for amicable settlement.
Okay.
Even when you go to court too, there are rooms for amicable settlements in court. You understand? We have the arbitrations where you can go to and then they discuss the issue, they resolve the matter. We have the mediation. We also have the reconciliation. There are special bodies that you can go to. You can even, without going to court, go to the body that this person is acting under. Let's say, for example, if this person is a lawyer, instead of going to court, I want to go to the Nigeria Bar Association and meet the president or the chairman. You can sit in a round table and discuss. It's okay. I'm sorry. Okay, this is it. This is a compensation, and the matters go like that. You can go to the NMA, Nigeria Medical Association. This doctor did this, and then you just sit down and it's resolved amicably. So, court should be, as a matter of fact, our advice that court should be the last step in negligence issues. Seek for amicable settlement outside court. If it does not work and the person is probably stubborn, then you can enforce your rights in the court of law.
By going to court?
Yes.
All right. We have seen instances where victims are being rushed to the hospitals and the doctors or the nurses or any medical practitioner that is on ground will request for police reports before they are being attended to. Is there any law that is about to be set in place, or is there any law in place presently that restricts that, probably giving first aid first before requesting for? I think that should also be a way of reducing the mortality rate as a result of probably negligence or that.
And before now, the position is that it's not just every injury that requires police reports.
Okay.
Yes. For instance, the injuries like gun injury, yes, those ones they require police report because the police will be mindful not to be treating an armed robber. You understand? But like I said, the reasonable man standard. Instead of waiting for the police report before saving this man's life, why not commence your treatment? The doctor is not the only person in the hospital. While the treatment is going on, you send a staff or a worker to the police station to inform the police that this is what is going on in the hospital right now. It could be that this person was even attacked by armed robbers, and we've heard of different scenarios where this person was attacked by armed robbers, and the doctors, they insist that not until they see the police report, they would not treat the person. It turns up that the person died, and this person was actually attacked by armed robbers. So why not commence the treatment, try to save the life while the process is ongoing? I did the matter, the doctor commenced with the treatment. While the process was ongoing, he informed the police. And then later it turns out that he was an armed robber. But the good thing he did was that he informed the police, who were already on ground in the hospital. So the moment the armed robber recovered, they apprehended him. You understand? So assuming he was not an armed robber, assuming it was someone that was attacked by an armed robber, and doctor says, let me wait for police report, and then they will take the person died. So I would advise that they should go on with the treatment. And although there's no law right now, the position is still as it were, where doctors will require medical police report first. But like for the matter I did, I think I've done series of cases where the DPO would advise the doctors to just commence with the treatment and send signal to us. We will send men down. I feel that is proper in that situation.
Proper and advisable. Well, indeed, it has been an educating time on Law Society and it's time for us to call it a day. And on behalf of course the FM and television, Hot News Communication, we want to say a big thank you to our host, to our guest for today's show, Barrister Charles Ogene Doro for sure. Thank you so much. And we hope to see you more often and often too.
By God's grace.
All right. Indeed, we have come to the end of today's edition of Law Society, and the topic for today was negligence. Indeed, the best way to avoid being liable is to take necessary care, proper precaution to ensure that the person who is your neighbor, not just the person living next door, the person close to you in the vehicle, in the bus, walking by, should not get injured as a result of your act or your omission. I remain Chinyere Abiamoy. Thank you for staying with us.